Did you know that 41% of workers in a survey recently stated that they had been bullied in their workplace? That should tell you that if you feel bullied, you are one of almost half the workforce in that situation. We work with individuals and businesses to help identify and address issues like bullying. What does bullying mean? Workers report being excluded from decisions, discussions and meetings, colleagues colluding or ganging up against them, being set unrealistic targets or an excessive workload, and being humiliated in front of others, for example. In nearly every instance of this sort of conduct, people also report having suffered health-wise. Often this is manifested in absence through stress or depression. Employers will not believe this is happening in their workplaces. They have anti-bullying policies and feel that they have done enough, believing that everybody complies. Why don't employees report bullying? As a victim of bullying, you may not have reported such behaviour, and you're not alone. Many believe that there would be retribution for exposing bad behaviour. Employees worry that their careers will suffer and they might be given unpleasant or dead-end tasks. Does raising a concern mean that you are not resilient enough for the workplace? If you can't stand the heat, get out of the kitchen. I shall say what you can do later. So what should employers be doing? Doing nothing is not an option, and employers that do not address bullying head-on face becoming known as a bad employer. That will not attract or retain key workers. Ignoring bullying does not make it go away. Rather, it may become part of the ethos of the company and embedded. There is a duty of care for employers to look after the health and safety of their employees, whether in terms of machines and physical dangers or from psychological dangers arising out of the conduct of employees. An employer can be regarded as liable for the conduct of its workers even if it is blameless and has the correct policies and procedures in place. This is known as vicarious liability. The courts assign responsibility to the employer even when it can show that bullies have acted outside of their contracted duties. On occasion, even when they do the opposite of what they were supposed to do. In a recent case, a supermarket was held to be liable for the actions of its employee who carried out a sustained assault on a customer. What can you do if you are being bullied? If you don't feel able to tell the person affecting you to stop the offending conduct, you should speak to a manager. Many employers have anti-bullying and speaking out policies, helplines and grievance procedures. You should use these mechanisms to report bullies and stop the conduct. There are various independent helplines and organisations outside the workplace, and of course you can speak to an employment lawyer who deals with this sort of issue. What is the connection between bullying and discrimination claims? There are discrimination claims for a sort of bullying known as harassment. The law says that a person may bring a claim when an employee's workplace is intimidating, hostile, degrading, humiliating or offensive. The conduct needs to be unwanted and violates the dignity of the employee. Where bullying is perpetrated on grounds other than race, sex, disability, age, sexual orientation or religion and belief, for example, or the other protected characteristics, for example in relation to weight or height or colour of hair, it is unlikely to be a discrimination claim unless it meets other criteria. Where personal injury is caused, it is more likely to be a personal injury claim which is pursued in a county court. How does the law help? Where an employee complains about bullying and harassment on the grounds of one of the protected characteristics, such as race, sex, disability, age, and so on, the employee attracts protection, and indeed any colleague complaining on behalf of an employee who has been bullied or harassed may also attract protection. Any detrimental treatment towards these individuals expose the employer to a claim from those individuals. So if a white colleague is subjected to bad treatment because he has complained to the employer about his black colleague being racially harassed, the white colleague could also have a claim for victimisation on the grounds of race. An employee complaining about bullying, which is not on grounds of a protected characteristic, may also be given protection from detrimental treatment because they have in effect blown the whistle on treatment that could damage their health and safety. It is important to realise that you are not alone and that you can do something about bullying and harassment. Discrimination is unlawful, and there are significant claims that can be brought. It is important to choose your lawyer carefully, preferably one who has experience in discrimination claims and who can assist you with the right tactics from the outset. What should an employer do when faced with these issues? If you're an employer who is facing a complaint of bullying or discrimination, you should seek legal advice at the earliest opportunity. An early resolution of such complaints is vital and could save you a great deal of time and expense. Whether you are an employer or an employee, the workplace does not have to be a place of conflict. These sorts of issues are resolved fairly easily as long as all the parties cooperate and work for resolution.